Market Foundation here at Northwood's House. We're absolutely delighted to be joined by our in-person guests who have just enjoyed a refreshing glass of wine, which I hope has opened up your minds for what will be, I'm sure, a very stimulating evening discussion. And welcome to those of you who are joining us online, live streaming on our YouTube channel. Please do feel free to make comments in the comment section and engage with us there. Thank you to those of you who have joined us. So we are very proud to be hosting this, our first evening event of 2024. It is entitled Limiting Power and the Rule of Law, Constitutionalism Beyond the Constitution. And we're very proud of this, this event because it is to celebrate our head of policy, Martin van Staden, who is a very significant figure for the Free Market Foundation, who recently won first place, ex aequo. My Latin is not very good, but for lay people like me, that means jointly awarded. So he jointly first place in the European Center for Austrian Economics Foundation's 16th International Vernon Smith Prize for an essay outlining precisely what the meaning and the purpose of the rule of law is. And here is a copy of that essay. It is called The Rule of Law, the Universal Unwritten Constitution. And Martin was very lucky. He got to travel to Vaduz in Liechtenstein, where he received the award from Prince Michael and Prince Philip of Liechtenstein. So we wanted to learn more about Martin's essay and his arguments, and we want to understand just exactly why he received the recognition of European royalty for his work. So copies of the essay, if you haven't already picked one up, are available. If you're joining us online, you can find that on our website. We'll put a link in the description. So just a little bit about Martin van Staden before we kick off tonight. He is the head of policy here at the FMF. It's a position that he has held since June 2023. But his involvement with the Free Market Foundation extends back all the way to 2015. He's also a member of the Free Market Foundation's Executive Committee and the Rule of Law panel of advisors. So Martin has presented oral evidence to the Parliament of South Africa and deposed amicus curiae briefs in the Constitutional Court. He's written books, a copy of which, again, you can find outside on the table, as well as multiple articles. He's appeared on television and radio on topics of public policy, jurisprudence, and economic policy. He holds a Master of Laws, an LLM degree, cum laude, from the University of Pretoria, which is also where he is currently pursuing his doctorate in law. Martin previously served as a deputy head of policy research at the Institute of Race Relations, and he is also the editor of the IRR's Race Law Index project, as well as the IRR's History project. So he has a very proud pedigree within the South African liberal community. Just a few housekeeping notes. Please, if you could switch your cell phones onto silent or preferably airplane mode, just so that we don't disturb everybody here tonight. As I mentioned, we are recording this session. We will be having a Q&A session after Martin's formal remarks. Martin will speak for about 30 minutes. If I could ask you, when you ask your question, just to use the microphone, just so that people back home can hear what you're saying. All right, but absolutely delighted to be handing over to Martin to discuss the very pertinent topic of the rule of law and constitutionalism. Over to you, Martin.
Thank you, everyone, for taking the time to join us here tonight. As David said, this event was prompted in light of my recent trip to Liechtenstein to receive the 16th International Vernon Smith Prize from the European Center of Austrian Economics Foundation, a very long name for a very proud institution, for my essay titled The Rule of Law, the Unwritten Constitution, which I do encourage you to please pick up the booklet and read for yourselves. Now, some of the photos that were taken at the princely wine cellars in Vaduz will be looping behind me on the screen. I will not be using any slides for the presentation itself, but if you feel uncomfortable looking at me the whole time, please do look at the screen there as well. Now, it was a great honor for me to meet the princely family of Liechtenstein. I always have to remember they're not the royal family or anything like that, the princely family. In particular, Princes Michael and Philip, who handed over the prize. And it's definitely the first, and I'm very sure the last time in my life that I'll meet royalty. But I think it is worth noting to an audience with very likely liberal and at least Republican sentiments that the princely family is not quite like other royals. Their head, Prince Hans Adam II, who is the reigning prince, so-called, of Liechtenstein, wrote a book, The State in the Third Millennium, where he makes the case for a small and limited government, and small states in particular. Now, this book cost me 1,000 rand due to Ramaphoria and the New Dawn and all those wonderful things. So I would not recommend going to Liechtenstein if you don't earn euros or anything like that. Don't make the mistake I made. But like neighboring Switzerland, where I also had the honor of spending some time, Liechtenstein encourages a form of direct democracy. There's a high degree of citizen involvement. Now, the House of Liechtenstein, the princely family, didn't ask me to bow or, God forbid, remove my hat. They only asked me to greet the princes with Your Highness, which I think is fair enough. The princely family makes the large bulk of their wealth from business and from investments rather than from extractions of tax money, like the royalty who lives in the Union buildings in Pretoria. Now, Liechtenstein's is a limited form of royal privilege that I think is acceptable to me as a libertarian and as a radical liberal, if you will. Now, the competition that brought me to Liechtenstein was premised exclusively on writing an essay exploring the meaning and purpose of the rule of law. Now, some of you in the audience, I think, did attend the launch of my book, The Constitution and the Rule of Law, an Introduction, in 2019. So, and then some of you hopefully have maybe read the book. That'll be great as well. So much of this might be familiar to you. But in writing this particular essay for an exclusively foreign audience, a European audience, and of course a jury of judges who had to judge the essay, I had to abstract away from the distinctively South African experience, and that's difficult for lawyers to do. So I wanted to look at the idea of what the rule of law, what this term, the rule of law, immediately conveys, even without a particular national context. But let's start with what the law is. So unlike doctors and scientists who speak only one language all around the world, science, medicine, jurists and lawyers have usually regarded ourselves as kind of islands. We focus on diversity rather than sameness or universality, as law is said to be entirely contingent on the society within which it finds itself. But as far as I'm concerned, to speak of law anywhere is to speak of the same thing everywhere. Whether we are in South Africa, in Liechtenstein, in Argentina, in Taiwan, what have you, the law is always going to mean the same thing. Law is a rule that, in the minds of the populace, is strictly binding and for which violence may be used to secure compliance. Now, law has always existed everywhere, and people have always instinctively understood what law is. So that is the law. What about the rule of law? Well, the term is the rule of law. Clearly, the idea is that it is the law that rules, as opposed to arbitrary caprice or the whims or preferences of some political class. But then understandable confusion arises. The National Council of Provinces in South Africa, the upper house of our parliament, just adopted or approved the expropriation bill, which will soon become an act of parliament, what we call a law. Does obeying the Expropriation Now Act that the law rules, thank goodness, rule of law? Well, indeed, the rule of law is often employed as a guise for authoritarianism, to cloak itself in the language of justice. We have to observe the rule of law, we are told, when there is talk of a tax revolt or non-compliance with some very harmful instrument like lockdown regulations or the NHI. We have to observe the rule of law. So is the rule of law then not a useless concept to people like us, free marketeers, liberals, free thinkers, advocates of liberty generally? Well, not so fast. To recognize whatever emanates from parliament or government, ministers and so on, as law, even if it is called law, would necessarily be to recognize what is known as the rule of man, would it not? For if we think that there is a distinction between these two phenomena, of men ruling and of law ruling, then surely it cannot be so simple for man to just call whatever he prefers law. More must be required. So clearly the law has always ruled. As I said, people have always understood law, and understood law to mean binding rules that can be coercively imposed. What then is the point of the now seemingly redundant idea of the rule of law? Well, there is an elephant in the room, and of course, when you're at a Free Market Foundation event, that elephant will always be the state. The state has taken for itself the power to make law. This understandably introduces difficulties for those who are concerned with the rule of law. Because if the state can make law, then we are not really talking about the rule of law, but the rule of whoever happens to control the state. The state, in whatever form, whether it's tribal, Neanderthal, chiefly, liberal, totalitarian, fascist, has always, and probably will always, have a very tense relationship with the concept of law. So for the longest period of human history up until relatively recently, the state or the absolute ruler or the tribal chief, whatever exists in that position, has regarded itself as though it is the source of legitimacy of the law, and if not quite so grand, simply that it is above the law. The law did not apply to the supposed sovereign. Principes legibus salutis est. The laws do not apply to the prince. But it was the classical liberal rejection of absolutism that brought about what we know today as constitutionalism, which is the idea that even the state, and certainly perhaps especially the state, must be bound and limited by law, just like everyone else is, like all of us are. If the state is truly subject to law, then it's the law that rules. Where the state rules, and controversially perhaps where the people rule, the law does not. The law must rule. The idea of constitutionalism then brought about a notion of public law. The law as it relates to the state's relations with legal subjects, and the relations between state entities. Public law or state law must necessarily be accompanied by a notion of the rule of law. Because if the state too is subject to law, then it follows that the state itself cannot control, at least not fully, what is meant by law. Something external to the state must exist so that it may control the state and therefore subject the state to it. So we have the seemingly redundant term of the rule of law precisely to communicate the phenomenon that the state is also subject to the law. The implication of this is that the rule of law exists only in the public or state law paradigm. Now, some of our former colleagues at the Free Market Foundation just could not understand this, and kept insisting that private organizations and people somehow must obey the rule of law as well. And the answer is no. Private organizations and people are already subject to law, primarily the common law or legislation and regulations and so forth. The rule of law is only for the state, and only in those circumstances where law has been made. So that is phenomena like legislation, regulations, or the binding precedent set by our courts. The rule of law plays no role in a contractual agreement between parties, nor should it. It only becomes relevant if those people who go to court over the contract in a dispute, then it becomes relevant because the courts are state entities, and when they solve the dispute, they make law. So the judgment of a court must satisfy the requirements of the rule of law. And what exactly then are these requirements of the rule of law? And why do I have the temerity to say that that the rule of law is a universal phenomenon that exists externally to the state per se, not any particular state, but all states? This is where, in my view, the real beauty of the rule of law shines through. Because we can easily deduce all the notable requirements of the rule of law from the very logic and nature of public law and lawmaking itself. No communist, fascist, democrat, or liberal should have any reason to disagree with any of these requirements. So briefly, a law anywhere is a rule that is binding, check. To not adhere to that rule is regarded everywhere as worthy of punishment, check. Now here enters the rule of law. For that legal rule to be binding, people must know about it. Check. So that rule has to be published. It must be made available, and its availability must be publicized so that people know that it has been published. Check. More than that, the people who are bound by the law must be capable of understanding the rule and be capable of complying with the rule. Check and check. The rule obviously cannot apply retroactively. Publishing a new rule, but saying it applied long before publication is simply a non-starter. Non-retroactivity. Check. The legal rule must be unambiguous, at least contextually. This means that the words describing the rule must clearly point to the very thing that the rule seeks to achieve. Check. There must be certainty around the rule, meaning it cannot constantly change. It must also be explicit rather than implied or unstated. Check. Now, there is one more requirement of the rule of law that I will get to later, but for now it suffices to say that from everything I have just said, if those requirements are not met, the so-called legal rule is not law. Why? Because it would defy logic and causality, not even to speak of justice and fairness, to expect people to obey rules that are not known, that are not accessible, that are not understandable, that are impossible to comply with, that apply retroactively, that are ambiguous, and that are uncertain. There is no point in making law if these requirements are not met. Now, while the notion of the rule of law might have been conceptualized in the West, and I think we must give the Western tradition the due recognition it deserves, there is nothing Western about the expectation that a binding rule must be known, accessible, understandable, etc., to those who are expected to comply with it. What then is the definition of the rule of law, if you take all of what I've said into account? So scholars have often struggled to come to grips with a set definition of the rule of law, preferring usually to describe the rule of law includes this and excludes that, rather than just defining it. I think there is enough widespread agreement over what the rule of law seeks to achieve in theory and practice to come to what I think is this apt following definition. The rule of law is the legal institution that regulates or attempts to eliminate state arbitrariness. If you unbundle state arbitrariness in this context, one might say arbitrariness in the making, content, and application of public, that is state law. None of this, of course, is self-enforcing. And I think all good liberals and libertarians by now should know this, otherwise traffic in a terribly dangerous form of naivete. The state routinely throws the rule of law by the wayside, naturally never admitting that it has done so. It's like minimum speed thresholds on our roads. Where did they come from? I think they came from the thumb of some former Minister of Transport. Where exactly is the rule itself found? The sign at the side of the road is not the source of the rule. The K53 book you buy at CNA is not an act of parliament, nor is it a valid regulation. What about traffic circles? Is it yield to the right, or do you treat it as a four-way stop? Important philosophical questions. We might all unanimously agree in this room what the rule is, but out there, I guarantee to you, there is a hell of a lot of ambiguity. Traffic law is a hot mess when you look at it from the perspective of the rule of law, but it is not the only one. Most pieces of legislation and regulations, which again are so-called laws that are consciously made, in some manner do not comport with the most basic requirements of the rule of law. Now, while a cogent argument can be made that the rule of law is itself concerned directly with protecting liberty and property, my view is that it does so indirectly. Eminent scholars have, however, over the years noted that there is a close relationship between freedom and the rule of law, because the rule of law is concerned with the legal control of state scope and state power. This is because the rule of law abhors arbitrariness, and arbitrariness is how tyranny ultimately flourishes. The rule of law, as far as possible, seeks to ensure that legal subjects, us, are governed by law and not by the whims or caprice of state officials. Hence the contrast with the rule of man, and why a defining characteristic of the rule of law is that both governor and governed must be bound by law. This necessarily follows from the notion that it is the law that rules, because only a rule of man could produce legal privileges for a political elite over legal subjects. During the COVID-19 lockdown, Bheki Cele, a civilian, the Minister of Police is not a police officer, contrary to what he might believe, was running around the beaches of Cape Town, harassing beachgoers for not being home indoors. This random, normal civilian who happens to hold a political office thought that he could do that. Now, if any one of us did that, we would have been arrested. Our law, at least implicitly, carved out a privilege for Cele as a member of the political class, the political elite, certainly, to do things that would land others in prison. So when politicians or officials moan and groan about the rule of law nowadays, that is nothing more than virtue signaling. It's a new term that some of you might be familiar with, on their part to benefit from the formal appeal of the rule of law without any intention in substance to adhere to it. If you read the essay, I make a point about how liberal constitutionalism is the constitutionalism of the world. We have won a massive victory as liberals, and we see that because dictators in North Korea and in Iran and all these people claim to adhere to the rule of law. What a wonderful victory that we have won. But of course, that is an empty gesture that they're making. So when you actually get these politicians and even scholars who agree with them to truly to engage on the topic of truly adhering to the rule of law, they would tell you that they cannot, because the requirements, as I have spelled them out, are too strict. Some who do not subscribe to the idea of limited government have even asked how the state could do anything at all if it adhered strictly to the rule of law. Imagine, things like zoning regulations, building codes, much of traffic law would tend to fly out the window, all likely because they are not accessible to the layperson. One of the key reasons is simply because there is too much law out there. As part of the Free Market Foundation's Section 12 initiative, which aims to provide workable solutions to South Africa's endemic violent crime crisis, we launched a criminalization index a few weeks ago, which you can find at section12.org.za. We haven't even scratched the surface yet with this index, and have already cataloged hundreds of crimes in the portfolios of minerals and energy, communications and digital technologies, employment and labor, and transportation. This is not what you think about when you think about criminal justice. Communications and digital technologies, crime, seriously. So most people do not know about even half of the crimes that we have discovered. And I think that alone, that fact alone, means that the rule of law is in jeopardy. So yes, most, if not all, state activity would have to fall away if the rule of law were to be taken seriously. This is the point of constitutionalism, which is a product of classical liberal legal thinking. To subject the state to legal control and to ultimately keep it within bounds. So that the state is prohibited from doing something is not a bad thing, and don't let anyone tell you otherwise. Adherence to the rule of law would allow the state to only produce basic justice, rather than the very complex and substantive conceptions of justice that we see being implemented all over the world. But how can it be that the rule of law so strictly controls government in a democracy? You might ask, a democracy is also a classical liberal phenomenon, surely. The notion that government must govern according to the dictates of the governed, whatever they might be. How can this be if at the same time the rule of law stops government from doing most things? The error here is that we look at history, at the history of ideas through the lens of modern understanding. In the days when classical liberals were rejecting absolutist rule in favor of representative government, democracy did not mean what we think it means today. Today, democracy opens the door to a virtually unlimited conception of law. Provided that the people have elected the legislature can slap the label of Act of Parliament on any piece of paper and write whatever the people demand into that paper, and then that is, we are told, law. Back then, however, the notion of law was significantly less fluid. Law had a definite content, usually understood to be the common law, the jus commune, not to be confused with the English common law tradition, but rather the common law of a society. Representative assemblies were not primarily regarded as being institutions that make law, and certainly not institutions that set the common law aside in favor of whatever their own political preferences happen to be. Democracy was about limiting the power of the executive branch of government, hitherto, at that stage, the absolute monarch. Not about creating another unhinged legislative branch of absolutism, which I think very much we have today. Now, of course, legislation did exist, as F.A. von Hayek and Bruno Leoni tell us, but these instruments did not, as a general rule, dictate behavior to legal subjects. The common law already did that quite ably. Instead, legislation was largely inward-looking, regulating and defining structures and objectives of government rather than dictating to those outside government. But do not misunderstand me. I am not saying that before the modern notion of legislation came about that there was a utopia of uninhibited individual liberty. No. The sovereign, the absolute ruler, who was thought to be the source of law or certainly not bound by law, still had the power to tax, to expropriate, to enforce all manner of things like public order and morality. But that was not a matter of law as we understand it today. There was no Income Tax Act in ancient Mesopotamia. There was no law of intestate succession in Neanderthal society. Taxes and expropriation certainly existed, and we file these things under law today. But back then, they were simply part of the sovereign power, which the common law did recognize. We take it for granted today that every aspect of government must be enabled by some legal provision. There must be an enabling act or an enabling provision, usually in a supreme constitution, but failing that in some form of legislation. This is constitutionalism. But constitutionalism has not always been around. Constitutions have always been around, but constitutionalism has not. Liberals thought it best that all government behavior must become defined within the ambit of law, because that is where it is most easily possible to limit that power. The next hurdle that now has to be controlled for is the arbitrary whims of man manifesting themselves in law. And this is where we wrap back around to the rule of law. The rule of law does not focus itself on ordinary legal subjects like us and tell us to obey the law. Running a red light does not mean you have somehow violated the rule of law. The rule of law is about controlling the manifestation of the arbitrary rules of man inside the state and lawmaking entities. Now, a while back I said that there was a final requirement of the rule of law that I would circle back to. I left it until now because this is the trickiest aspect, I would say, of the rule of law. And it is intimately related to what I also refer to as basic justice. I have used the word arbitrary and arbitrariness several times now, but we have to now look at its opposite. What is the opposite of arbitrariness? Reasonableness. The final requirement of the rule of law is that the legal rule must be reasonable. The legal rule must have a reason, a good reason. It must address itself to a mischief or a problem that is to be solved, and it must do no more than solving the problem that it has identified. And this mischief, this problem that has been identified, must be based on something more than whim or preference. It must be based on evidence. Furthermore, a normal person, or what is in law called the reasonable person, must agree that the legal rule is reasonable. So you can see why things get difficult here. What is a good reason? The African National Congress and economic freedom fighters say that they want the expropriation bill to right historic wrongs. Many people will say that this is a very good reason. Others will say that it is not. The Democratic Alliance might say that South Africa should not trade with authoritarian regimes around the world that invade their neighbors. Some might say that this is a very good moral posture in foreign policy, and others might say that it harms the South African economy. So what is and what is not a problem that is to be solved by the legal rule? Everyone will disagree about this question. Is the fact that white South Africans own a lot more property than black South Africans evidence that the expropriation bill should be adopted? Many will say that it is evidence that the expropriation bill should be adopted, and others will say it has nothing to do with the price of eggs. Reasonableness is difficult, but it is a key and irrevocable part of the rule of law. Remember, the definition of the rule of law, as I have stated it, is to minimize or eliminate state arbitrariness. Now, if you put that in reverse, the rule of law seeks to maximize or totalize state reasonableness. You cannot get rid of reasonableness as a requirement of the rule of law So how do you deal with this difficulty? One of the most cited American legal thinkers, Cass Sunstein, criticized F.A. von Hayek specifically because Sunstein says that Hayek had no good criterion for what arbitrary means. When is something arbitrary and when is it not? That is to say, what is arbitrary to me as a libertarian is certainly not arbitrary to a socialist. And of course, we all know by now that postmodernism says that everything is arbitrary. So basic justice returns to provide us with what I think is the answer. As I have already explained, adhering to the other requirements of the rule of law, other than reasonableness, must produce basic justice. This is because it will be extremely difficult for the state to formulate legal rules that are knowable, accessible, unambiguous, and certain. All these boxes must be ticked. It sounds easy enough, it's not that easy. Perhaps the main reason for this is because there will need to be far fewer legal rules in absolute numbers to render them accessible to the layperson or knowable. There can't be hundreds of thousands of crimes spread across the regulatory state, not even to speak of acts of parliament. The requirement that legal rules be understandable will also mean that much of the very, very complex stuff that you find in regulations nowadays will have to fall away, simply. The result is significantly fewer legal rules that get closer to approximating basic justice. Now, what is basic justice? Basic justice are those things that I think we can say everyone, or at least every lucid person of sound mind, agrees is not arbitrary and is or should be within the purview of law. We know that very few people agree about everything that must be within the purview of law, so this list of things will be very short and very few and far between. Basic justice then encompasses a very, very short list of things. Every liberal, libertarian, capitalist, communist, socialist, fascist, Muslim, Christian, and atheist will agree that the legal rules against murder, rape, assault, trespass, and destruction to property are proper legal rules. Communists certainly disagree with capitalists on what the scope of the notion of property is. I'm not saying that they agree in the fine detail, but even in communist society, property exists. It's what communism is ultimately all about, whether it is leased or owned. A communist in Maoist China will report a crime to the police if someone else is squatting inside the house that they have been allocated by the Politburo. So there is still a sense of basic justice, a sense against trespass, even amongst communists. But this is not hard science, ladies and gentlemen. I cannot tell you the exact overlap of agreement, only that the general rule of thumb is that the more we move into more debatable areas of law, of which there are many, where people can have reasoned disagreements, and where each party to the disagreement has at least some sensible arguments on its side, we venture into the realm of the legally arbitrary. Why? Because this is where we will necessarily have to defer to the discretion of the appliers of law rather than to the law itself, to come to a clear conclusion on those disputes. But the more we move into less debatable areas of law, where there is not just more agreement, but basically unanimous agreement, which are the things I've already mentioned, the closer we move to basic justice, which is shared across virtually, I would say, all the ideological spectrums of the world. The law, then, is almost necessarily arbitrary when it attempts to give effect to the notion of substantive justice of any individual or group. Each of us, of course, does require a substantive conception of justice. We would not be human if, as individuals and as communities and as groups, we did not have a substantive sense of justice. But the law, and I must say public law, must steer very well clear of it if it takes the rule of law seriously. And it won't necessarily steer clear of it if it implements the requirements of the rule of law as I have stated them. Enforcing my conception of substantive justice, or that of my group, must be legally arbitrary in nature. And I think everyone understands this at some basic level. The law against working on Sundays is very important to Christians. But it simply makes no sense to enforce that on those who are not Christians. There is no basis for that. The expropriation bill fits very neatly into the conception of substantive justice of many South Africans, surely. but it is totally irreconcilable with those of others. There is wide agreement, for instance, about restitution. Everyone from the Free Market Foundation to AfriForum, to the EFF, to the Communist Party, agrees that where property has been taken, there must rightly be restitution, where this can be shown. And that is clearly, restitution is very clearly a matter of basic justice. But the other aspects, like redistribution, like giving government a wide and very much unlimited discretion about what and when to expropriate, that is a matter of significant agreement, which you cannot say there is wide, unanimous agreement about. Now allow me to conclude. These laws that give effect to substantive conceptions of justice are necessarily unreasonable or arbitrary, because depending on your own conception of justice, you would not buy into the good reasons for those laws or accept that the problems that they address are real problems, and you will almost necessarily reject the evidence that is provided to justify them. Only laws that give effect to basic justice are reasonable in this sense. Anything else falls outside of the scope of the rule of law, and therefore outside of the scope of public law. This is a form of unconstitutionality that exists beyond our written constitution. And these laws that are unconstitutional in this sense, I submit, are not necessarily binding in conscience. And if that is the case, obeying them in practice is not truly a duty, although it might be very wise to obey them in a very selfish sense of self-preservation. So don't read too much into what I said. Were the strict standards of the rule of law then truly observed, we would be left with a framework of basic justice that enjoys widespread, if not unanimous, legitimacy. And it is in this way that the rule of law indirectly, but substantially, does serve liberty. Thank you.
Well, thank you very much, Martin. That was an excellent exposition of your paper. I just wanted to point out that, and as I mentioned earlier, Martin is a member of our Rule of Law project. He's a panel member, and we have several panel members here today. And as an institution, we as the Free Market Foundation are dedicated to upholding and preserving this very sacred idea of the rule of law. Unfortunately, it seems to be more honored in the breach these days. But I think it's very important that civil society groups such as ourselves really draw some very strong lines in terms of preserving that tradition, the rule of law tradition. All right, I'm going to hand over now to the audience. I'm sure you're itching to ask questions, but is there anybody who would like to ask? Mark Oppenheimer, who is represents the rule of law project on public interest litigation.
So, Martin, one of the big debates about the rule of law is that you've got, as you've described quite well, Lon Fuller's inner morality of the law stuff. So it can't contradict itself. It must abide by these sort of logical rules. You must know about the rule in advance. You can't punish people for stuff that they did before the rule existed. And then the more controversial point, I think taken up by Lord Bingham, is this idea that the rule of law necessarily encompasses certain substantive things. So that the rule of law guarantees you your natural rights, like your right to life or right to property or whatever other rights people want to dream up and put in constitutions. Now, that strikes me as controversial. It seems to be a different category of things. It might be that it's useful to pretend that the rule of law grants us these other things to achieve certain objectives. Do you think it does?
It's a difficult one. I think it does indirectly. I don't think that that is the objective of the rule of law, but I think it would be difficult for an act, for instance, to prohibit acquiring property or to enable, like the expropriation bill does, the widespread expropriation of property, without falling into one of these traps about it being unknowable, about it being uncertain, certainly about it being ambiguous. If people have read clause 12 and 13 of the expropriation bill, that says that effectively the government can just expropriate your property with no compensation for any reason. It has some lists, but there could be other reasons maybe on a good day. I mean, you could never know as an owner. You could never finally know whether my property is going to be the target of expropriation or not. So it's virtually unknowable. It's entirely within the discretion, in this case, of the Minister of Public Works, I believe, and their delegates. So it's not that the rule of law protects your property. It's that the rule of law says you can't act arbitrarily and capriciously. And by expropriating property, you're necessarily acting arbitrarily and capriciously. So that could be applied to free speech and so on. That's where this reasonable aspect comes in, where prohibiting one person's speech might seem very reasonable to a lot of people, but ultimately it's extremely debatable. Whereas prohibiting murder, prohibiting rape, these things are certainly not debatable. Certainly on your philosophy show they are debatable, but amongst 99.99% of the population, these things, people don't think about these things because it's taken as given. And in law we know these as the Marlines say, things that are criminal by their very nature. And this is a very small list of things. So yeah, it's not that the rule of law protects freedom and liberty directly, as in it's a principle of the rule of law, but the rule of law seeks to ensure that whatever the law is, it is reasonable, it is knowable, it is accessible, and if you want to do those bad things against those substantive values, you would necessarily be acting in a way that is not accessible, that is not knowable, that is not reasonable, certainly.
So my worry is the reasonableness that you're adding. That seems to draw on natural rights. I mean, first of all, I think we could draft a really evil law in a way that is incredibly clear. So you can have a whites-only bench, and with some clear level of clarity, we know who's allowed to sit on that bench, and you can say, if you sit on it, if you're not white, we're putting you in jail for 90 days. It's very clear, it abides by the rule of law, it's an evil law, and a positivist is going to say, it is law, you are being punished by the law, and you ought not to obey it for some good moral reason. But I don't know if you can rest on the rule of law to say, well, it's unreasonable, therefore it's not a law. I also wonder about how ambiguous things are in other areas. So, for example, thou shalt not kill seems very clear. What if it's in self-defense? What if I'm drunk? What if it's in a battle? What if it's by mistake? There's lots and lots of ambiguity on things that seem very clear. And so I would think you've got to be careful about saying certain things are unknowable in principle. Well, they are. We find out through the common law, we find out through clashes of facts. That's how the law operates, even in these very clear cases like killing.
But there is no law that says thou shalt not kill. The law says you may not commit murder, and murder is a very specific kind of definition, and it includes things like necessity that justifies private defense and so on. So that is, even the Marlines say of the law against murder already takes account of that. So it's the same with trespass. If you have to cut over someone's property because some bandit is chasing you and shooting at you, the law would say that you have not broken any law, even if you, on a very strict constructivist reading, committed trespass. In fact, you did not. So the law already takes account of that. And that would be recognized in the common law, as you've said. But yeah, I mean, the reasonableness for me isn't necessarily, it doesn't see, I don't think it draws on natural rights. I think the key here is the level of cross-cultural, cross-ideological agreement that you can find. And to me, it seems relatively clear that no matter where you go in the world, if you just take a random person from the street in Bangladesh, and you take a random person from the street in Chile, in Greenland, and in some base in Antarctica, you will find that there is a very, very short list of things that they agree perfectly about. And I would say that this would be: murder must be illegal, rape must be illegal, or whatever equivalent term they have in their languages or in their modes of thought. There will be huge agreement on a very, the point here is it's a very, very limited list of things, because people do not, as a general rule, agree about many important things. So there will be a very small list of things that they agree about, and a hell of a lot that they disagree about. And I think that if you apply this reasonableness test in that context, only laws that deal with the agreement thing can be reasonable, because there's a reason for it that is recognized by all of them as a good reason. There is a mischief that they all agree is in fact a mischief. And there is evidence there. There is, again, it's another way of saying there's a reason that they all would agree is a valid reason. But it's a very short list, and this is the key thing. You don't have to be a liberal communists agree with liberals about the very minimum that the state must do. What they disagree about is that they think the state must do far more. So it's not that there's disagreement about what few things the state must do. There is total agreement about that, I would say. But the disagreement is about what more the state must do. And I think that solves the problem. I think that solves the problem. I think if I had Julius Malema here with me today, I would be able to get him to agree with me to find unanimity with him on basic justice. The only thing that we would disagree about is that he would say the state must do more. I would say the state must stick to basic justice. So on what is relevant to me, we agree. As far as I'm concerned, in that debate, I won because I only needed him to concede the basic justice, and I think he would. Oh, well, okay, maybe not Mr. Malema. I remember the videos on YouTube, but maybe one of his colleagues.
Yes, he was a bit of a moral relativist.
I did say lucid and yes, yeah, he's maybe the exception. I chose a very, very bad example there. Mr. Zuma, maybe.
If you could please introduce yourself and speak into the microphone, but also loud enough for everyone. Yeah.
I don't think it's on. No, it's not.
Test.
It's not coming through the speaker, but it's for the report. It looks good. Use it, please. Please use it.
So I beg your pardon. My apology. As everyone here, I think, knows, the rule of law is a founding principle of our Constitution. I think it's Section 1. Mark will know better than me. One of your principles of the rule of law is that it should be certain. Could you just repeat for us, Martin, what the grounds for expropriation are in the proposed expropriation bill, so we can test that against the requirement of certainty as part of the rule of law? Thank you, sir.
Yes, thank you. As memory serves, there's 5 items that are listed, but very explicitly the bill says that it's not limited to these 5. Yes. So the 5 are, from what I remember, one of them is the property, if it's abandoned, then it's liable to be expropriated without compensation. So if you as an owner no longer exercise control over the property, if it's been abandoned. That's one ground. I think there is another ground that says if the property is used for purposes of speculation exclusively, then it is liable to be expropriated without compensation. There is a land reform criterion. I can't precisely remember how it was framed. So yeah, the 2 that I focused on were that I'm really concerned about is the abandonment one, for instance, because the law defines abandonment very clearly, and in our context, if someone does a land invasion onto your property and you are evicted unlawfully from your property and you spend 5 years trying to get your property back and you fail, and you're like, well, okay, I guess I'm going to wait it out now. You would have abandoned the property, and then the government can say, oh, wonderful, we'll expropriate it without compensation, when you are clearly the victim in that. So yeah, I mean, on those grounds and just based on what in the bill, because the bill cannot rightly be taking abandonment as the common law understands it. It must have a far narrower conception of abandonment for that to be a just provision. So there is already ambiguity about what the bill means by you do not exercise control over your property.
Thank you. The worry, of course, is that it can be anything, but including the following specifics, and the worry is the anything.
Exactly.
I think that is it. Interesting, as I think, again, we all know, is that it's only Section 2, which is the Bill of Rights onwards, which is subject to the limitation provision in Section 36, again, Mark. And so the rule of law is not limited by Section 36.
Yes.
I just wanted to make that point.
That's an important point. So in this essay, I don't explore that point, but in my book, which is on the table over there, I really focus on this point. So the rule of law is found in Section 1C of the Constitution, and it is elevated to a supreme value of the Constitution. It provides that South Africa is a nation founded upon, amongst other things, the supremacy of the Constitution and the rule of law. Now, a lot of people overlook this. It's a conjunctive thing. It's not only the Constitution that is supreme. The rule of law is declared by the Constitution to be co-equally supreme with the written Constitution. It's all there. And it's certainly not limited because it's not in the Bill of Rights. But what I alluded to in my remarks now was that it's almost been normalized by the political class everywhere to limit the rule of law simply out of the nature of governance. So, my goodness, if we had to adhere to the rule of law, then we can't say that you have to have a meter of separation with your house from the sidewalk. That's a municipal rule. But I mean, I want to build up to the sidewalk. It's my property. I want to do that. And people realize that you can't get away with all these nice things that people like to govern about if you really adhere to the rule of law. The rule of law is extremely strict in that sense. The mere fact that these rules differ from municipality to municipality, the mere fact that every municipal official can issue regulations that are not in the bylaw, the provincial housing MEC can issue regulations that are not in the Act, the national housing minister can issue regulations that are not in the Act. So there's reams and piles upon piles of pages of rules and law that you have to be familiar with if you want to be what is so venerated in South Africa today, law-abiding. This silly, terrible idea of marching to the tune set by the political class. No one here is law-abiding, I promise you. Not one of you. And no one out there is law-abiding because you cannot be. It is impossible. And that itself is a total subversion of the rule of law.
Thank you. All right. Any other questions? Terry?
I'll give a comment rather than a question. Martin, you mentioned zoning, which is very interesting, you know. I don't know how many people are aware that Houston, and I don't know where the situation is now, but Houston until about 20, 30 years ago had no zoning laws whatsoever. It was about, I think, the only major city in the world that had the situation, and they used to vote it in and over again. Now, how did it operate? All the things that you're talking about, should there be a building line and so on, would be in what they call the covenant or in the title deeds. So if you go to the beginning, there was 5 farms next to each other. You know that if you had one farm and you wanted to develop it, you wouldn't like to have a sewage works on your corner there. So you didn't arrange them with people. And a lot of these interarrangements so that there was a right to restrict the person there. Interesting enough, there is a book called Land Use Without Zoning by Guy Bernard Segan, and I visited Houston in the 80s. And what was fascinating was that if you go to Houston, you don't know about that. It's not all that different, except for a few things. People on either side of a road own their property to the center line of the road, except for the fact that the road, a couple of meters below and a couple of meters above, was there. If you wanted to put a bridge over or a underpass under, you didn't need to go to the municipality. You just went to the guy on the other side and you could do that. So I reckon that there's probably more undergrounds and bridges in Houston than anywhere else. And the other thing was that Segan said that he thought that the efficiency and the economics of it was better because people were also always, it was more market related. But it was based on property rights, and that's very, very important. And these covenants were very strict. If you know, today if you're in an area, somebody can buy up a corner there and put a filling station in. Yeah, if you bought anything in that any property in that area, you would have to get something like 80 or 90% agreement on whatever was written in that title deed.
Yeah, thanks, Terry. I mean, you bring up a good point there, and the problem here is that what you've described to me is order, but what the political class would see is absolute chaos. They would regard that as total chaos, which obviously is ridiculous, because we see that the market institutions produce real order. The person who won the third place in this Vernon Smith Prize, a photo of him is going to come up now, a chap from India. If any of you have been to India before, you'd have seen how the traffic there works. And he played a video for us. His talk was a little bit more economics focused than mine, but obviously with this rule of law angle. And he showed a video of where it's an intersection of effectively 2 highways where the cars just keep going. Like to my mind, I would want to say that is chaos. But the video plays over several hours, and you don't see one car, like big accident. The car is just they just keep going. That is order, ladies and gentlemen. That is order. That is not chaos. Because chaos is where you see death and destruction and violations of rights. But the political class would see that, and they see what you describe as chaos. And that is why what you just described is no longer the case in Houston, because this centralizing tendency to bring everything under the watchful control of our superiors in government is extremely powerful. And the rule of law is one of the things that I hope kind of militates against that, but one has to buy into the rule of law first.
All right.
David, I think that gentleman.
Oh,
Yeah.
Rich, please introduce yourself and speak into the microphone.
Thanks, Martin. Thanks for a very stimulating talk. Just a couple of thoughts. It's Richard Meyer here. I'm an attorney. And I was just reminded, just given the situation, the legal debates about the Middle East, Ukraine, and the various disputes regarding what agreements were breached and what the historical legal position is. I was just wondering if, in your paradigm, you're obviously looking at a national situation, but do you feel there could be any scope for the rule of law in the international context, albeit in an embryonic or attenuated way, given the fact that we're dealing with supranational circumstances?
So that is an extremely important question, and it's a question that I'm going to fumble in my answer. And that is because I am not convinced that international law is law. That is, it's a shorthand that we employ. We call it international law. It's not law. I think law is something that, as I described it, is something that the population widespreadly recognizes as something that is coercively imposable. There is some of that at the international level, but the kind of default to enforce it, it's simply absent. There is no enforcement mechanism, which I think is necessary to have law. So we call it international law. It's very unpopular for me as a libertarian to say what I'm about to say, but you need enforcement mechanisms at the international level that are binding. So you need something like the United Nations that has significantly more teeth, or teeth at all, or the International Court of Justice at the very least, at least some level, and Interpol that is in fact an international police agency rather than something that operates kind of by consent of the nations, because if the police arrive at my house, they should ask me for permission to enter, but if I say no, they can just come back and enter anyway if they get a warrant. Interpol cannot. If you as a country close yourself off to Interpol, they have no jurisdiction. There is no international military that can enter your property without consent unless the 5 Security Council members agree, and no one vetoes that, and that's going to be increasingly rare, I would imagine. So yes, I would love to see the rule of law at the international level. First, I would want to see law at the international level. We're certainly not there yet.
Okay, well, thank you very much, Martin. Staden, please join me in giving Martin a generous round of applause. And I just wanted to say how proud we are to have Martin in our team. He is an intellectual force, and we're really chuffed that he is getting the kind of international recognition that he so deserves, and the Free Market Foundation certainly benefits from that as well. So thank you very, very much for your industry and your passion and your commitment to the truth and to this cherished idea of the rule of law. And I also just want to say that the principles of the Free Market Foundation are that we espouse individual liberty, private property rights, a market economy, and limited constitutional government. And we haven't just chosen these things from a buffet. They are all intertwined, and they're indivisible, and they are part of what it means to be a free human being in a free society. And the rule of law is really the glue that binds that together. But I just wanted to hand over to Mark Oppenheimer, who I mentioned has represented the Rule of Law project in some of our most important public interest litigation. So we're not just theoreticians, we're also practitioners, and we get stuck in the arena of the courts. So Mark Oppenheimer, please do take the stage.
Well, I want to thank you, Martin, for an absolutely fabulous presentation, and it's wonderful that you're being recognized on the international stage as I think more and more people recognize you locally. One of the things that I find most painful about Martin is how young he is. that he has achieved so much and done. I mean, he's doing his PhD, he's got a book under his belt, he's winning international prizes, he's one of the leading lights in the liberty movement. And are you still in your 20s?
Barely.
Barely in his 20s. It is rather painful. But I think what's so important about the work that the Free Market Foundation is doing is building this theoretical framework so that when you need to take action, you're not doing so in an arbitrary fashion. You're doing so in relation to principles. To give you an idea, I was involved in a case this morning around the powers of Chapter 9 institutions, and we were relying on rule of law points to determine what Chapter 9 institutions can do, can they usurp the powers of other bodies. So these things are very practically useful and have big ramificationary effects. The Rule of Law Project, as David has mentioned, has been involved in some quite high-profile litigation in the Constitutional Court and the Supreme Court of Appeal. I think that the big battleground in South Africa really is in this realm of lawfare, that it's a useful stage, you can get your ideas out there, you can express things like equality before the law, like non-racialism, things that have been championed by the Rule of Law Project in court. And of course, those of you that are interested in funding the Free Market Foundation may want to consider funding, in particular, the Rule of Law Project. Martin, I want to say that we have a little present for you, and I hope you enjoy it.
Thank you very much.
Okay, thank you very much, everyone. Please do join us for another glass of wine and some snacks and some scintillating conversation. But that's it from us at the Free Market Foundation team. Thank you, everyone, for joining us, and thanks to the production team as well for making this happen. Until next time, stay free.